IS. Today we will discuss important judgment by Supreme Court on International Safe Abortion Day that has expanded the rights of women contrary to the trend seen in the other parts of the country. Now, you see that recently Supreme Court in a significant judgment has said that it is unconstitutional to distinguish between married and unmarried women. Now, the court has reinterpreted the Rule 3B, which we will be discussing in the class, of the Medical Termination of Pregnancy Rule 2003, which allowed only certain categories of women. This also we will be discussing in the class, that what are all those 7 categories of women which are allowed under the Medical Termination of Pregnancy Act, Amendment Act of 2021 to abort pregnancy. You can relate this topic with your General Studies Paper 1, that is Social Empowerment. The General Studies Paper 2, Mechanism, Laws, Institution and Bodies which are constituted for the protection and betterment of the vulnerable section. Now let's move on and we talk about what is medical termination of pregnancy. You see, the medical termination of pregnancy implies terminating pregnancy with the use of medicine. And gestational period is also very important when it comes to terminating the pregnancy, because the legal provision in India recognizes certain time limit of the gestational period when it comes to aborting a child. So gestational period, what is this gestational period? Gestational period implies the period starting from the conception of pregnancies till the time the fetus is born. Starting from the conception of the pregnancy till the birth of the fetus. Now let us discuss that why safe and healthy abortion practices are important. According to the United Nations Population Fund, an unhealthy and unsafe abortion is the 3rd leading cause of maternal mortality. The unsafe abortion is the 3rd leading cause of the maternal mortality in India. According to the State of the Population Report 2022, which is also released by United Nations Population Fund, it says that from the year 2007 to 11, 67% of the abortion in India were classified as unsafe. Now, what is this unsafe abortion? Unsafe abortion means that they are not conducted under the guidance of registered medical practitioner. They are not conducted in medical institution, or they can be conducted by the women themselves. You see, according to National Family Health Survey, 26.2% of the abortion occurred at women's house. That means these are the unsafe abortion practices that leads to death of the women, and hence unsafe abortion is the 3rd leading cause of maternal mortality. According to National Family Health Survey, 3% of the pregnancies results into abortion. The percentage of women opting for abortion in urban areas is 4%, while the same percentage in rural areas is 2.5%. Therefore, we need to have healthy and institutionalized practices of abortion. Now, what are the legal provisions in India when it comes to abortion? There were, in 1970s, an act came which is known as the Medical Termination of Pregnancy Act 1971, which recognized the medical and legal practice of abortion. Now let us discuss the parameters which were defined under the act, which can be categorized as cases that are recognized for the legal abortion. The first category is the contraceptive failure. We will be discussing each of these parameters. The contraceptive failures. In the 1971 Act, only married women were allowed. However, in the Amendment Act of 2021, the unmarried women were also allowed. That means the 2021 Act substantially changed the language of Section 3 of the Act to from married women and her partner, to women and her partner. What does this mean? This means that the legislation recognizes the pregnancies outside the institution outside the institution of marriage. Right? So the MTP Amendment Act of 2021 substantially changed the language of section 3 from married women and her partner to women and her partner. Now let's see the gestational limit. In 1971 Act, it was 20 weeks for all indication. However, in 2021 Act, 3 categories were defined. The first is within 20 weeks. The first category is within 20 weeks. The second category is within 20 to 24 weeks. And the third category is beyond 24 weeks. Right? For within 20 weeks, 1 registered medical practitioner will be required. Within 20 to 24 weeks, 2 registered medical practitioners will be required. And when it comes to terminating pregnancy beyond 24 weeks, an establishment of medical board will be required, which will have expert deliberation whether to abort the child beyond 24 weeks of pregnancies or not. Now let us talk about if there is breach of confidentiality. A fine of just 1,000 rupees. A fine of just 1,000 rupees was attracted in 1971 Act. However, fine and imprisonment up to 1 year is recognized in Amendment Act of 2021. Now let us see that how the court has interpreted. Now what is this Rule 3B? Now what is this Rule 3B? Now Rule 3B says that special categories of women will be permitted to abort the child within the limit of 20 to 24 weeks. Now what does this Rule 3B categorize? 7 categories of women. 7 categories of women. What are these 7 categories of women? We will be discussing in detail. The first category of women is survivor of sexual assault, rape, incest. Right? The second category of women are minors. Third category is change in marital status. Change in marital status. The court has reinterpreted this change in marital status. According to Rule 3B, the change in marital status is either widowhood or divorce. The court said, the Supreme Court of India said that widowhood and divorce are only for illustrative purposes, and it does not restrict the court to reinterpret the law and include within its ambit other categories of women. So widowhood and divorce are only and only for the illustrative purposes when it comes to change in marital status. The court said that change in marital status, the third categories of women, the change in marital status changes the women, the change in marital status changes the women's material conditions. Changes the women's material conditions. That means she might have dependents, right? She may not be able to fulfill the requirements of the pregnancies. So change in marital condition, change in marital status leads to change in the marital condition and also to the mental status of the women. Therefore, the court has reinterpreted the law and expanded its provision to include other women as well. This we already discussed, the reinterpretation of the law by the court. Now the fourth categories of women. The fourth categories of women are women with physical disabilities. Women with physical disabilities. Now this physical disabilities would be read along with the 2016 Act, right of person with disabilities. Whatever the conditions that have been, whatever the categories of the disabilities have been listed in this act would be recognized for the purpose of MTP Act. Right? Now let us come to the fifth categories of women. This is the language of the law. Okay, mentally ill or women suffering from mental retardation. Women suffering from mental retardation. This is the fifth category of women who will be allowed to abort the child within 22 to 24 weeks as per Rule 3B. Now, like I said, Rule 3B categorizes women into 7 categories who will be allowed to abort the child within 22 to 24 weeks. This is the fifth category. Alright. Now, the sixth category recognizes the fetal abnormalities. Fetal abnormalities. Now, if there is a substantial risk to the life of the fetus that it would be incompatible with the life and would suffer from the serious or grave mental and physical conditions, therefore the pregnancy can be aborted within the 22 to 24 weeks, within the gestational limit of 22 to 24 weeks. Now let's see the seventh categories of women. This category of women recognizes women in humanitarian conditions, disaster situation or other emergencies, disaster situation or other emergencies recognized by Government of India for the purpose of MTP Act, right? All those emergency situation and disaster conditions which will be recognized by Government of India would fall in the category 7 for the purpose of aborting the child within 22 to 24 weeks of gestational limit. 22 to 24 weeks of gestational limit. I hope everything is clear, right? 22 to 24 weeks of gestational limit. Now let us also see, let me take a white sheet. Okay. Now the MTP Act. The MTP Act of 2021, like I said, it conducts abortion, or it legalizes abortion, you can say. It legalizes abortion in two phases. The phase 1 is the within 20 weeks, alright, and phase 2 is within 22 to 24 weeks. Okay, this we discussed. This comes under section 3. Rule 3B. We will also discuss how further Rule 3B has been interpreted by law. And within 20 weeks, there are two conditions for this. First is the contraception failure. Contraception failure. The first point here is that if women and her partner, like I told you, the 2021 Act changed the language of Sectional 3 from married women and her partner to women and her partner, right? So women and her partner, the failure of contraception used by women and her partner in order to limit the number of children, right? In order to limit the number of children. Chalo, let's write it here only. This is first point, and the second point is the anguish caused by the unplanned pregnancy. The anguish caused by unplanned pregnancy, right? Why this has been recognized? You see, I told you that National Family Health Survey says that approximately 47% of the women stated that unplanned pregnancy were the reason for the abortion. Therefore, the Act recognizes the same. Let me delete this. The second point here, like within 20 weeks, first point we discussed failure of contraception, and in failure of contraception we discussed two subheadings. The first is for the purpose of limiting the family, that is number of children, and second is the anguish. Second categories can be divided into two parts. If it is likely that the pregnancy, the continuation of the pregnancy would pose serious danger or risk, more appropriate, to the life, mental and physical health of women. All right. The fourth point here in this category itself is the fetal malformation. That it is likely that the fetus would be incompatible. That the fetus will be incompatible with life. What does this mean? This means that the Constitution of India recognizes under Article 21 a dignified life. Dignified life, not a dignified life and not just survivability. Right? I'll move here. A dignified life under Article 21 and not just survivability. So therefore these are the four conditions laid down for the purpose of abortion within 20 weeks under MTP Act of 2021. And within 20 to 24 weeks we have already discussed in Rule 3B. What are the further interpretation that court said about Rule 3B? It says the first thing, no distinguishing. No distinguishing between married and unmarried women. Right? Second point, the court said, court is not restricted. Court is not restricted. And the third point, the court said that Rule 3B should not be read in isolation. Should not be read in isolation, but along with subclauses, right? So this is how Supreme Court of India has furthered the interpretation of the law when it comes to the right of women, when it comes to right of women. Now let us see what are the further interpretation of Rule 3B and what Supreme Court further said about Rule 3B in regard with the MTP Act of 2021. In reality, the Supreme Court of India has not strike down the marital rape per se, but it has included married women. Now please take note down of this, that it has included married women within the ambit of women, within the ambit of survivors of sexual assault, right? So court has not dealt with the marital rape separately. It rather has included married women under the category of survivors of sexual assault, so as to include marital rape category for the purpose of abortion. Court also said that there should be purposive interpretation of the law. There should be purposive interpretation. Now what does this purposive interpretation mean? That means for the purpose and object of law. For the purpose and object of the law. That means the court has not relied on the literal interpretation. The court has not relied on the literal interpretation of the act. For example, the change in the marital status of the women, where the court says that divorce and widowhood is only for the illustrative purposes and it does not restrict the court to reinterpret the law and include other women in the ambit of within the ambit of the law. So therefore the court has said there should be a purposive interpretation. Now let us see what is the impact of this judgment. The first point is that the court definitely court has definitely expanded the rights of women. Right? Second important point is that the judgment will have impact on recognizing the health of women. The health of women. Now health can be divided into two categories. It could be physical health and it is mental health. The judgment will have impact on both these health statuses, the physical as well as the mental health. Right? However, there are certain limitations of this judgment. What are those limitations? Let's see. The court definitely has expanded, but it has not recognized matter of choice. That means the abortion is still conditional. The abortion is still conditional in nature, right? It is dictated by law. The abortion is still conditional in nature and it is dictated by law and it is not a matter of choice. That means the judgment lacks bodily autonomy of the women. The judgment has not recognized the bodily autonomy of the women, whether she wants to continue the pregnancy as a matter of choice or as a matter of health condition. Right to life and motherly care. Right to life and motherly care. If the mother is not ready, if the mother is not ready to nurture the child, then the right to life and motherly care, then the child who is born out of such pregnancies will be deprived of the right to life and motherly care. It has not included everyone. What about the trans women? The Act does not recognize such category. And it also is reflective of the able thinking. You look at the language of the law. Mentally ill, mental retardation. It is reflective of what? Able mentality. It is reflective of the able mentality. What else needs to be done? What else needs to be done? You see, that sustainable development goal needs to be achieved by 2030. And SDG goal 3, it recognizes good health and well-being. Right? Article 14, equality, right to equality. Therefore, any law which is framed by the Parliament of India should reflect Article 14, should be reflective of the spirit of Article 14, that is right to equality. It should include everyone under its consideration, under the protection of the law. The second point is Article 21, right to life. Right to life. And not just the survival life, but a dignified life. Alright. The moral obligation of the state under directive principles. DPSPs. Directive principles of state policies. The state government, and by state I mean the government of India. The government of India is under moral obligation to provide good health and protection to every citizen of India by law. Alright. Therefore, considering the number of unsafe abortion that occurs in India, which is 26.2%, the number of unplanned pregnancies that occurs in India, which are the leading cause of the abortion, there is a high need that the Court of India, the Parliament and the citizen of India recognize the right of women and their bodily autonomy to recognize their right to health and a dignified life. Thank you. That's it for today. Have a nice day.